Go.
All right, welcome back to another edition of Live Read Feed or Live
Live
Feed
feed
Read.
reads.
We're late, Jason's fault. However, he made up with it by bringing his daughter Aurora. Come on over, say hi to TV Land. Look into the camera. Come over here, say hi. How old are you?
I'm 10.
Okay, and again, you do or do not have a boyfriend?
I do not.
Do you want one?
No. Boyfriends are evil.
There's more room.
Oh.
There's more room on my camera. You'll have to come over here.
Oh,
I've got yours square on you.
There.
So come over here
Come
and
over
squeeze
there.
into my camera.
and squeeze into his camera.
That way you can talk and people can see you.
Can you see? Let's do that again.
Yep.
All right. You say hello again? And what's your name?
Aurora.
And how old are you?
10.
And you're engaged to be married?
No.
Oh, okay. All right. So, well, thanks for coming. We're going to go ahead and chat with these people on TV land, so to speak, and go from there. All right. So, FYI, we've kind of got some new equipment. And so if the microphone doesn't work, if Jason's microphone doesn't work, if you have some feedback, if the picture's no good, if you can let us know, that'd be greatly appreciated. All right, today we're going to talk about the make-believe accident Jason and I were involved in on January 1st of 2020, pre-COVID. And I was driving and I crashed into Jason, even though I think it was Jason's fault. He thinks it's my fault, so he sues me, that son of a gun.
It's definitely your fault.
Yeah, exactly. So we have this lawsuit, and it goes through the discovery phase of interrogatories, depositions, and now we're set for trial. And I'm pretty confident that we're going to win, and because of the way Florida law works when it comes to automobile accident cases. And it's only Florida law, and it's actually no bueno. Because what has to happen for Jason to get, let's say his daughter was in it too. So we got Aurora and Jason, they're in the car, and they're both claiming to be injured. And they've sued me for medical bills, lost wages, and pain and suffering. All right, and so during the process, my insurance company, who's hiring my lawyer and so forth, gets to send Jason and his daughter to our doctor, so to speak. So we choose a board-certified orthopedic surgeon because Jason's saying he's having right shoulder pain and neck pain, and Aurora's saying her back hurts and things of that nature. So a couple of months before the trial, they go to our doctor, and he gives them an examination, and he looks at the MRIs and things of that nature, and he's going to testify at trial. Okay, so Jason, it's about 4 or 5 days is how long an average automobile accident trial goes. Jason puts on his case, we put on our case, both from a liability standpoint and we call it damages, basically lost wages, medical bills, past and future, and things of that nature. And so now the jury goes back and they start deliberating. And what you give them is what's called a verdict form. Okay, this is how it works. So the jury has heard the testimony over 3 or 4 days. They've heard from Jason's doctors saying he's injured, tells them that what his injuries are, reviews the MRIs. And then what's key in Florida, and we'll get to that through the verdict form, is they say that Jason and Aurora have permanent injuries within a reasonable degree of medical probability. Now remember that, because that's where automobile accident cases are fought in Florida and won and lost. And again, I'll explain it as we go through the verdict form, and I'll show you why this is so difficult and what jurors don't get to know, and why you can win the battle, meaning Jason could prevail, get the jury to give him some money, but still lose the war. All right, so the first question is basically, was there negligence on the part of the defendant, me, which was a legal cause of loss, injury, and damages to Jason and Aurora? All right, now remember, I'm taking the position that Jason did something wrong, that he's comparatively negligent. So they can say yes or no. Yes, I was negligent, or no, I was not negligent. Now, if they say no, I was not negligent, then I win. They sign the verdict form here on page 3, and we go home. So that's it. If for whatever reason Jason doesn't prove his case, then I win. We go home. Now, mind you, that is a 2-part question. What was there negligence on the part of defendant, Okay, that's the first question. Was I negligent? Was I driving careless? Question 2, which is subtle, which was the legal cause of damages to Jason Crawford. Now let's say that I'm taking the position, Jason and I was leaving the office, and we're right out here in front of the building, and we're at a red light. The light turns green. Jason begins to go forward, and then he stops for no reason, and I hit him. Okay, so I rear end Jason. Now, in Florida, you're presumed to be at fault if you rear end somebody, but it's a rebuttable presumption, meaning I can say, well, look, yeah, I rear ended him, but Jason stopped in the middle of the intersection for no reason. So basically, Jason stopped in a time and place where one would not reasonably expect that to occur.
Okay, so that's interesting because that is, I thought that if, getting hit from behind, it was kind of like you're screwed, you're at fault. So you're saying it's a
rebuttable presumption.
It is rebuttable.
Right.
But it is a presumption.
To your fault. You're presumed to be at fault. But the case is Eckler. It's a Supreme Court case where this situation happened. The person is going through an intersection and locks up their brakes allegedly for no reason. And me, the person behind him, said, look, yeah, I rear-ended them, but they hit the brakes for no reason. Therefore, I'm not negligent. Okay. That having been said, and Jason only has a scratch on the bumper. Typical situation nowadays, just because cars are plastic. And I've seen cars where, say, the rear end is smashed to pieces, and there's a scratch on the front bumper of the rear-ending car, and vice versa. Sometimes my car, the rear-ending car, smashed to pieces, and there's a scratch on the bumper.
Yeah.
So at this trial, Jason's got a scratch on the bumper, and my lawyers make a big deal of it. Ladies and gentlemen, how could Jason and Aurora be hurt with this scratch on the bumper? But Aurora's a sweetheart. Jason's a nice guy. He presented well at trial. And the jury says, yeah, we're going to give him the benefit of the doubt that he was hurt. Jason went to the hospital, and Aurora went to the hospital right after the accident. Then they had some follow-up treatment with the doctor, some MRIs and so forth. And so the jury says, yeah, we think he was hurt. All right, so then they say, if you check yes on this, go to question 2. Question 2 says, well, was there negligence on the part of Jason, which that contributed to this crash? Now they can check yes, or they can check no. If they check no, then they skip question number 3. If they check yes, Jason was also at fault for basically stopping in the middle of the intersection for no reason, then they answer question 3. Question 3, let's just say they check yes on this one. Question 3 says, well, how much was Paul at fault and how much was Jason at fault? And it's got to be 100%. So let's just say they give Jason 25% and me 75%. And they can give any percent they want. If you don't have your seatbelt on, let's say Jason doesn't have his seatbelt on and he has this big scar on his face. Well, my position would be, look, he wouldn't have that scar on his face. He wouldn't have hit the windshield if he had his seatbelt on. Hell, they may give him 90% at fault, saying you wouldn't have that scar.
Because there are other things you can do that are preventable other than just the accident itself.
Exactly.
Things that matter. Yeah.
Right. So, and the seatbelt issue used to be huge. Luckily, nowadays, most people actually wear them. So anyway, they find 75-25, and then it says, okay, go on to question 4. Question 4, what are the medical bills? What are the reasonable medical bills? And I'm just going to stick with Jason. I know Aurora was hurt. We'll get to hers, but so we're not here all day. And Jason's medical bills are, let's just say with the hospital and so forth, are $20,000. So the jury says, that's a lot of money, but Jason's a nice guy, and he wasn't, he didn't want this accident. So they'll write in $20,000 right there. Okay, so they say, okay, what is the amount of future medical bills? Well, by the time you get to trial, you probably haven't seen a doctor for well over a year and almost 2 years. This makes it easy for me, the defendant, i.e. my attorney, to have the jury say, look, he hasn't been to a doctor in a year. He hasn't been to a doctor in 2 years or otherwise. So don't give him any future medical money for future medical bills. Now, then you say, well, my doctor says that I'm going to need surgery. Well, that's Jason's doctor. He went and saw an orthopedic surgeon. Well, my orthopedic surgeon, of course, is going to say that when I examined Jason, he had fully recovered from the accident, and he certainly doesn't need surgery. So oftentimes people think, well, the doctor said I need surgery, therefore I should get $100,000 to pay for that. Doesn't work like that. If you have not had surgery, by the time your butt hits that chair in the courtroom, the jury typically is not giving you money for it. They're not taking it into consideration. As far as future medical bills, oftentimes, and we're not talking this catastrophic Terry Shriver type situation, oftentimes they don't give future medicals because you haven't treated in a year or two, and they just don't. So they put 0 on that one. The next question is lost wages past and future. Typically, these are easy to get. If Jason missed 2 weeks worth of work and he makes $1,000 a week, they'll write in $2,000. Again, with the future, the loss of future earning capacity, they usually give 0. Again,
Okay.
these are not the catastrophic cases. This is your average run-of-the-mill, neck injury, back injury, and things of that nature. So they put 0. So now we've got $20,000 past meds, $2,000 lost wages. All right. The next question, and here's where Jason loses. In Florida, under the Florida no-fault system, that's that PIP. And you say, why haven't the insurance companies hate it? They complain of fraud, fraudulent billing, all of this. Here's why they have not gotten rid of the PIP statute, the no-fault statute, and why they won't. In Florida, in an automobile accident, for Jason to get 1 penny for past or future pain and suffering, and there's a lot of terms we use. We've got pain and suffering, disability, physical impairment, disfigurement, mental anguish, inconvenience, and aggravation of a pre-existing defect, and so forth. All that's pain and suffering, basically.
Okay. And PIP is
remember, under the no-fault statute, remember, no fault basically substitute regardless of fault. Because remember, regardless of who's at fault, if you were hurt in this accident,
right,
and if I was hurt in this accident, regardless of me being at fault, your insurance company pays a percentage of your medical bills up to $10,000. And regardless of whether I was at fault or not, my medical bills are paid in lost wages up to $10,000 as well. Okay?
Yeah.
So that's this part of the statute. Right underneath, another section says this. Okay, because of this no-fault statute and Jason's getting some of his bills paid, we're going to enact this little paragraph, which is the death knell of these cases from a plaintiff's perspective. Jason, in order to get any money for pain and suffering, has to have died. Well, that would be a wrongful death. But either way, death. Death would be one where your estate, your family and parents and kids and stuff could get pain and suffering money automatically.
Okay.
Number 2, if Jason or Aurora had a significant and permanent scar as a result of the accident. In this situation, neither one of them does. They were both wearing their seatbelt, and they have neck complaints and shoulder complaints and things of that nature. So far, neither one qualified. The third one is loss of an important bodily function. If you are incontinent because you have low back and you can't go to the bathroom, eyesight, smell,
Do you know what incontinence
hearing.
means? You don't know what incontinence means? Want to explain what that is?
Long story short, you can't go to the bathroom, or you have difficulty going to the bathroom, or you go to the bathroom too
Can't
often.
poop. Or you poop too much.
Yeah.
It's mostly pee though, right?
Yeah. Either way, it's just, yeah. I wasn't going to elaborate, but sicko over here. All right. So either way, so far, none of the above. And here's the catch-all. The catch-all is that, back when I said 10 minutes ago, the permanent injury within a reasonable degree of medical probability. Jason's doctors say, yes, he does have a permanent injury, but my doctor says, who's also board certified orthopedic, says, look, I examined Jason 2 months ago, a month ago, he's fine, and he certainly doesn't have a permanent injury. Well, jurors do not like to figure out how much somebody's pain and suffering is worth. And in fact, when you talk to them before trial, one of the questions is, do you believe in awarding money for pain and suffering? Many will say, I do not. Many will say, I don't mind giving medical bills, I don't mind giving lost wages, but I don't think someone should be compensated for pain and suffering damages. Of course, they get booted off, but that's neither here nor there. But that's a problem. The ones that stay on there, they don't like it either. So then the question is, this is where they take the easy road out. Did Jason sustain a permanent injury within a reasonable degree of medical probability as a result of the January 1st, 2020 accident? If you check no, then basically add up lines 3 and 4, which is your medical bills and lost wages, and sign the document and give it to the bailiff. If you check yes, then answer the next question, which is, how much do we have to give Jason for past and future pain and suffering? They take the easy way out. They compromise. Because you're going to have some people that want to give Jason money, some people that don't want to give him money. So what do? They say, you know what, let's split the baby. We'll check no. That way we don't have to figure out past pain and suffering, because when you go into trial and most people that are injured with herniated disc and things, they don't look hurt. You can't see it. They got nice clothes on. Their hair's done. Now, granted, they'll get up and tell you, yeah, my back hurts and I can't sleep and I can't pick up my kid and I can't do all these things.
Yeah, but it's not like they wheeled them in on a
they
hospital
can't see
bed
it.
and sit them up and have them testify, right?
Those don't go to trial.
Right.
They pay. Give me all your money, okay, have a nice day.
Yeah.
Remember,
So
the cases that go to trial are basically the ones where the insurance companies are pretty confident they're going to win, or they will give you enough money to not risk it. Okay. And so so they check no. Let's say they check no. Then they add up the $20,000 plus the $2,000, and they put in here on this verdict $22,000. Okay. If they check yes, then they give you money for your pain and suffering and things of that nature, and that will basically be a win. So when they check yes, then the plaintiffs are usually pretty happy. They bought everything you were selling and so forth. But let's say they check no, and now they put $22,000, and Jason's thinking, and the jury's thinking, well, we did all right by him. We gave him $22,000. Well, what the jury doesn't know and what they can't and what they're not told is this. So let's go back to this section where your medical bills are, and they wrote in $20,000. Well, what they don't know is a few weeks later, the two lawyers will come back to the court, and I'll say, Judge, my lawyer will say, Judge, Mr. Crawford had personal injury protection benefits, his no-fault benefits. They paid $10,000, and part of those bills are also under a fee schedule. Example, when you go to the hospital and they submit to PIP, let's say it's a $10,000 bill. Right off the bat, they have to write off 25%. So that's $2,500 gone. So let's say part of that was your bill, right? So they write in $20,000. We come back 2-3 weeks later, 4 weeks. Okay, John, Your Honor, he got $10,000 from PIP. So now that 20 is down to 10. And I say, also, Your Honor, the hospital submitted, they wrote off $2,500. So now that 20 minus 10 minus 2,500. So now you're down to $7,500 here, right? Okay. And there would be more because there's fee schedules, but let's just stay simple. So now you're down to $7,500. Okay. And then your lost wages, they gave you $2,000, but your PIP paid 60%. I'm not a math major, but that's like $1,200. So now your lost wage claim is what? $800. So now, and you got no money for pain and suffering. The judge will say, okay, Jason, you get, do the math, $7,500 plus, you get $9,000, $8,500.
Okay, yeah.
Okay, well, a year ago, basically, or 6 months ago, we're at a mediation, and the insurance company says, we'll give you 10 grand. And you're like, no, that's not enough. We lost mediation. And normally, or I should say often, the mediation number is more than what these reductions I'm talking about are, minus no pain and suffering. Again, if you get the pain and suffering, then it was worth going to trial. Typically, without that, you typically lose.
Okay.
Now here's the kicker. What people don't know: Florida's a loser pays state. So let's just say we went to mediation, and the insurance company had offered $15,000, right? And they do it in a formal pleading. It's called a proposal for settlement.
Okay. And
so that's on there, and it's $15,000. And now after trial, we come back, and your verdict or your judgment's $9 grand, right? Not only would you not get that $9,000, you're going to owe $50,000 to $100,000 in the other side's attorney's fees, because the statute says this: if either side makes an offer once the suit is gone on for a little while. If you basically don't come within 25% of that offer, or from a plaintiff's perspective or the defense, if they don't beat it by 25%, then you owe the other side's attorney's fees from the date that offer was made.
Wow.
So you can win the battle. You won.
Yeah.
You got $9,000, right? A verdict
Right.
after reductions.
Yeah.
But we had offered you $15,000
Right.
2 years ago, and you didn't take it. And I'm not a math major, but $9,000 is not within that 25% of 15 grand.
No.
And like say 11 or 12 grand. So now Paul Reed's lawyers, insurance company, otherwise said, Jason, by the way, you owe us $41,000. You were hurt. Jury believed you. They gave you your money. They gave you your lost wages, and you go home owing me $41,000.
Wow.
That happens all the time.
Wow, I didn't know about that.
No one does.
Wow.
Right. That's why automobile accident cases in Florida are difficult. And for Aurora, it's even more difficult because it's very, 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 very hard, if not impossible, for a jury to believe that a 10-year-old child has a permanent injury for the rest of her life.
Gotcha.
And so what
unless it's like obvious, which you said they are.
Well, obvious they pay.
Right.
But you know, the back still hurts and whatever.
Mm-hmm.
And the insurance company, let's say she didn't treat as much as you, her bills outstanding after PIP, maybe you had some health insurance, her bills are $611, after the reductions.
Mm-hmm.
So the insurance companies offer $611, and you as a father are offended. Are you kidding me? My little girl was hurt. She cried for 6 months and this, that, and the other, and she had nightmares and all those things that do happen.
Yeah.
And the insurance company or says, well, I get it, and I feel bad, but you're entitled to $611. That's what we're offering. And the jury, they give you all this. They do the math, and here, Jason, here's $611.
Yeah.
And by the way, you didn't accept the proposal on her either. There's another
more
whatever.
Fees.
Yeah.
There you go. Welcome.
Yeah. So.
Wow. That's interesting. That's
well,
really interesting.
In lies why it's just you just can't go to trial and say, well, it's the lawyer's money and I got nothing to lose.
Mm-hmm.
We'll give it a shot. Well, in a sense that's Florida's a loser pay state.
Yeah.
So like I say, and I tell people, we can win the battle. It's really relatively easy, except on that scratch on the bumper case. But even that, if you're a nice person, they will tend to give you your medical bills and lost wages.
Yeah, but it's not just about winning the case. It's about winning it
well,
a certain measure. And there's other things.
Put it this way. On your case, your lawyer spent minimum $25,000. So you got a $9,000 judgment after it was entered. Now, you can get your costs associated with that. So they'll give you some of it back. But your problem is, guess what? Because of the proposal for settlement, you get nothing. In fact, you get a judgment against you. So then you did not prevail. So your lawyer doesn't get any of his costs back. So your lawyer spent 3 years of his time on your trial, on your case, spent $25,000 and gets zero. So he's basically out 3 years of services rendered and minus 25 grand. Who does that? I mean, that's like going to work for 3 years and not getting paid, and then your employer saying, hey, by the way, you owe me 50 grand. So as much as, Ryan and Jackie and I, we're not pissing and moaning. We do just fine. But understand, there's a risk in this business. And when you take that risk and you lose, not only do we want to win, I want to win more than anything. I mean, I grew up with baseball. I grew up playing sports, grew up with competition, and it's a fight. It's a fight in there, and you want to win. So not only do you get a gut punch, because it sticks with you. It makes you almost want to quit the profession every time you lose at anything. And so then you feel bad for your lawyer. Feel bad for Jason. Say, yeah, buddy, we took it on the chin. Sorry, it's hard to get over that scratch on the bumper that you had, and I know it was a decent impact, and yada yada yada. But pat you on the back, have a nice day. Jason's going down to the federal courthouse filing bankruptcy. Yeah, it's a bummer.
Yeah.
So
that's wild. I didn't know all that. That's interesting. It's probably not related as a question, but
Shoot.
I was wondering how like you were talking about pain and suffering and all those. I was
Mhm.
wondering how like mental health doesn't seem to factor into a lot of things when it comes to medical needs, just in general. I'm not talking about legally.
Right.
Like a lot of stuff is very difficult to be covered by insurance and things like that. And I was curious how, if at all, any of that gets established in any of these cases.
Sure. Well, here's the thing. Part of the number 8, when it comes to pain and suffering, disability, physical impairment, mental anguish is that psychiatric or psychological component.
Mm-hmm.
But here's the problem. If someone is bringing a mental anguish complaint, saying I have psychiatric or psychological issues related to this accident, typically speaking, they have prior psychiatric and psychological or mental health treatment. That muddies up the water. Because as a defense lawyer, what do I get to do? Jason, you've seen a psychiatrist before, haven't you? What were you seeing the psychiatrist before?
Right.
Depression? What was that depression related to?
Right.
And on and on.
How do I prove the
so
nuance
as a defense, I'm throwing mud in the water and I'm stirring it up, and the jury's like, where did we go?
Yeah. How can you measure it? How can you prove what?
Right, and you had all this beforehand.
Yeah, right.
And Jason, didn't you spend 2 years in a psychiatric hospital because of this, that, and the other? Yeah, and so now you're trying to say that this minor impact created your post-traumatic stress disorder?
Mm-hmm.
Come on, man.
Yeah. Wow. Wow.
Yeah, dude. Yeah. So it's just a lot goes into it,
Mm-hmm.
and until you've tried cases, which, hey, toot my own horn, I've tried cases in 8 different counties, not just Hillsborough County, and not just a bunch of cases in Hillsborough County, Pinellas County, Pasco County, Polk County, Orange County, Highlands County, Manatee County. Woo-hoo! Yep. And so Sarasota, I don't know how many that is, probably more. But either way, but it's all the same. It all boils down to the same thing. This permanent injury within a reasonable degree of medical probability, and that's like Superman having to jump over the Empire State Building. Because remember, insurance companies try their best cases, or they would settle. Plaintiffs try their worst cases, or they would settle.
Mm-hmm.
Just that simple. And so when whether you have Reed and Reed or you have some other lawyer, understand going to trial is risky and it's not easy. And so that having been said, I don't know what else we can do today. I lasted about 20, 25 minutes. So
yeah, we've had a good number of people. Brian Staley was with us again today. He says, "Happy Friday." Of course, he asked if we have any grandchildren yet.
Me? No. Yeah.
You could have mine. No, I'm kidding.
Yeah.
I'm teasing.
Yep, not yet.
And then he says it's never Paul's fault. So there's that.
Thank you. I'm a very good driver. Jason stopped in the middle of nowhere. It's all on him.
We have Brandon Johnson with us who says, "Thank you for the education." Which is really cool.
No, that's why we're here to have a little fun and educate people on certain aspects of the law.
It looks like Struggle Needs Strength. It looks like it's another Facebook page that dropped in to say hi.
Welcome.
Cool.
Yeah, welcome.
And I think that's it. I don't have any other questions for you. Like this was all very informational. I know I learned some things about it. So just thank you.
What do we want to do? Because we upgraded our system, so we have a situation where if you have a question, they should submit it, and I can try to address it on Friday. Now, mind you, I can't give legal advice. That's always a disclaimer.
Obviously.
But I can address the question. So go to the website, Need Read.
For sure.
Shoot.
Or just the Facebook page is the
Facebook page.
Yeah,
why, you got that?
Yeah, I've monitored that constantly.
Okay, either way.
I can queue them up.
All right.
For sure.
And then and submit a question. I'll try to answer it.
Yeah, absolutely.
I mean, we do personal injury, but I did go to law school, so I can research the issue and give you
it might be nice to dive
cogent
into some
answer.
other cases that are out there.
Yeah.
And just be like, what's going on? Can we break that down? And
And like I said though, it's funny, a little ditty here at the end. People call because I was born and raised literally a mile and a half from here, and they say, "Paul, I have a domestic divorce and this. Can you help me?" And I'm like, "Well, only if you want to lose the house, the dog, and the kids." Other than that, you might want to get a divorce lawyer.
Yeah.
All right. That having been said, let's. By the way, Ryan and Jack, you're in New Orleans. Yeah. Hi, Ryan and Jack. Yeah. Lovely. Have fun.
Yeah.
Go Bucks.
Go grandkids.
Yeah.
No,
that would be grandmother. Go grandkids. All right. So we're out.
All right.
See you.
Bye, guys.
Okay.